Hello, my name is Kim Stanger. Welcome to this presentation today. This presentation is offered by the Idaho Hospital Association and our firm, dealing with mental holds in Idaho. A little bit of background here. It seems like I've received a lot of questions from different hospitals around the state dealing with mental holds recently, so I was talking with the Idaho Hospital Association, and we thought it might be well to provide this webinar to hopefully provide some insight concerning what the rules are. As far as preliminaries, we've provided you with copies of written materials. Hopefully, you should have received an email with the links to that, including copies of the PowerPoints, copies of relevant statutes, an article that I did a while back on changes to the mental hold laws that occurred some time ago, and I've also, just this morning, updated a sample policy dealing with 24-hour mental holds. That should be available on our website. If you haven't accessed that, if you go back in and access that through the link that Laura probably sent to you, you should be able to access all of those written materials. By all means, feel free to shoot me an email if for some reason you have a problem with that. If you downloaded the materials yesterday, I apologize, I didn't get a chance to update some of them until this morning, and so the slides that I'm using today may be slightly updated from the version that you downloaded yesterday, for which I apologize, but hey, didn't have time before. If you have questions during the program, you can submit them using the chat feature or just email me at the address that's up there on the screen. Because we're going to record this program, we decided that we weren't going to necessarily record the questions, but you can certainly contact me offline and I'll respond to those questions. This webinar will be recorded and available for free download at our website at that link that's up there in case you want to use it in future training or go back and review any of the information or don't have anything better to do for a date night on Friday night. We would certainly like to welcome especially representatives from the Idaho Department of Health and Welfare who graciously agreed to participate today, especially Tamara Prysock and Debbie Ransom. I think that they may have had some commitments that prevented them from actually being on the line, but they did promise to, or graciously agree that if you have questions, particularly dealing with the mental health issues and the licensing and survey issues that may sometimes arise in the mental hold context, that you can go ahead and email me those. I'll make sure that I get those on to Tamara or Debbie, and they graciously agreed to respond to those. All right, with that said, let's launch into talking about mental holds. Before you can talk about mental holds, you have to step back and understand the whole general concept of consent. In Idaho, the general rules for consent are as follows. A competent patient, a patient having sufficient capacity, generally has the right to decide their own care. What happens to them? They can consent or refuse to their own care. If the patient lacks capacity or is incompetent, then you generally can't just provide care without some type of authority. Similarly, if a competent patient refuses care, you've got to have authority to hold that patient. Now, if the patient's incompetent, maybe you have an advance directive from the patient that would grant you that authority. If the patient's incompetent and you don't have a contrary advance directive, then you may have consent or obtain consent from an authorized surrogate. Unless you've got consent from the patient or the authorized surrogate, you generally can't provide treatment or hold the patient unless you have some authority granted by statute. There's a couple of statutes that do grant you authority to go ahead and provide care, even though you may not have consent. The most important of which is probably the Idaho statutes. Two statutes, in fact, give you authority to hold and provide emergency treatment for an incompetent patient, and also the Idaho statutes allow, in certain circumstances, to provide or initiate what are called mental holds. We'll talk about that more later. Now, when it comes to those mental holds, remember that the purpose of that mental hold is not necessarily just to treat the patient against their will. Instead, it's to hold the patient while you seek an order from the court that allows you to provide ongoing care or treatment for that particular patient. If you don't have authority by one of the foregoing, either consent from the patient, a competent patient, or consent from a surrogate, or some kind of statutory authority that allows you to hold and treat a patient, then you could be liable for any number of torts or criminal action if you hold that patient against their will. just simply because you think that that patient needs care does not authorize you to hold that patient against their will or without proper authority. If you do so, you could be liable for false imprisonment, kidnapping, battery, lack of informed consent, or anything else that a patient or their attorney may want to pursue against you. Now, I get the question sometimes, well, we were going to place the patient on a medical hold, not necessarily a mental hold. We're going to place them on a medical hold. There is no such thing really as a medical hold under Idaho law. There is a mental hold, but there is nothing talking about a medical hold. Now, granted, the gamut between what is a medical issue versus a mental issue, you know, that's kind of a slippery slope. You don't know exactly where one ends and one begins. So you have to go back to the general rules. Generally, under the Idaho statutes, the way that they're structured, if it's a medical issue, then generally you follow the general consent principles that are found in Idaho Code 39-4503 and 4504 that I'm going to talk about in just a minute. The general rules there are the competent patient may consent to their own care. If the patient's incompetent, then you get consent from a surrogate. If it's an emergency situation and the patient's incompetent and you don't have time to find a surrogate, then you go ahead and provide care, and the statute authorizes you to provide care as if you had proper consent. That's generally for medical issues. When you're dealing with mental health issues, well, you've got a couple of options there. The first is, of course, you can always follow the general consent principles, just like you do for the medical issues. But there may be some circumstances where the patient refuses, even though they may be competent, or the surrogates refuse care. Or you may not be able to get consent. In those situations, in the mental health issues, you also have the options of initiating either a 72-hour administrative hold if you satisfy certain criteria and you are a mental health facility, or a 24-hour mental hold per Idaho Code 66-326, or in the case of minors, you could detain them under the shelter care statute. We're going to talk about each one of those. But let's back up and let's talk about the general consent issues. General consent under Idaho, our Medical Practices Act, or our Idaho Consent Act, states the following: that any person who comprehends the need for, the nature of, and the significant risks ordinarily inherent in any contemplated health care is competent to consent thereto on his or her own behalf. If the patient has sufficient capacity to understand and appreciate the consequences of what they're doing, they can consent to or refuse their own health care. Now, who makes that determination? Well, initially, it's the health care provider, the treating provider, makes that initial determination. The statute goes on to say that any health care provider may provide such health care and services in reliance upon such consent if the consenting person appears to possess such requisite comprehension at the time of giving consent. So if you've got a competent patient there, then the competent patient can generally decide what happens to them. They have the right to consent to or refuse care, and there's not a whole lot you can do about it. On the other hand, if the patient lacks capacity, they're incompetent, then Idaho Code 39-4504 sets forth who can consent on their own behalf. That statute says that consent for health care to any person who is not capable of giving consent or who is a minor may be given or refused in the order of priority set forth below. And then it gives you a list, a hierarchy of those who can consent for this incompetent patient. But before you get to those people, you have to remember a couple of rules. First, that surrogate decision maker, if you're going to rely on the consent from that surrogate decision maker themselves has to have sufficient comprehension as required to consent to their own health care. So they would have to satisfy that standard in 39-4503. They would have to appreciate and understand the consequences of what they're doing, okay? Not only that, that surrogate decision maker can't have authority to trump the prior expressed wishes of a competent patient. So if that competent patient told you what they wanted to have done to them after they become incompetent, then you've got to go with that. You can't allow that surrogate to trump the prior expressed wishes of that competent patient. Those prior expressed wishes may be given in the form of a formal advance directive, or they could just be their prior expressed wishes that they made known to you and that hopefully you've documented. But let's assume that you've got an incompetent patient, you don't have an advance directive, and you've got a surrogate, then the statute says that the following are surrogate decision makers who can make health care decisions for that incompetent patient, either to consent to or refuse health care for them. The way this works is you start at the top and go to the bottom. So the people up at the top have more authority than the people down at the bottom. First is if there is a court-appointed guardian of such person. That is not just the guardian in kind of the generic sense like a parent, it's a court-appointed guardian. That person's been appointed by the court. The second is, if there's no court-appointed guardian, it would be the person named in another person's durable power of attorney for health care, assuming the conditions for that durable power of attorney have been triggered, meaning that the patient's incompetent. If there's none of those persons, then it would be, if the patient's married, it would be the spouse of such person. If there's no spouse, then it would be an adult minor child, an adult child of such person. It shouldn't be minor there, it should be adult child. So if you've got a 64-year-old father who's incompetent and you've got a 35-year-old son, then you can look to the 35-year-old son as long as there's no spouse. If there's no adult child, then it would be a parent of such person. If there's no parent, then you could rely on any relative of such person who represents himself or herself to be an appropriate, responsible person to act under the circumstances. So that could be a sibling, it could be a grandparent, it could be a cousin, whoever else is appropriate under the circumstances. If there's no family member, then the statute says you can rely on any other competent individual representing himself or herself to be responsible for the health care of such person. That could be maybe a significant other, could be a foster parent, some other person that represents themselves as being appropriate under the circumstances. Now, it may be a situation that the patient comes in, it's an emergency, you don't have time to contact a surrogate, you don't know what the patient's prior expressed wishes are, and the patient's incompetent. What do you do there? Well, the statute goes on to say that if the person presents in a medical emergency or there's a substantial likelihood of his or her life or health being seriously endangered by withholding or delay in the rendering of such health care, and the person is not communicated and is unable to communicate his or her treatment wishes, then you can go ahead and provide necessary care to take care of that emergency. Even if you don't have consent, you're deemed to be able to provide that care even without the consent. We have actually a separate statute that makes it a little bit more clear. Idaho Code 56-1015 says that no physician or hospital licensed in this state shall be subject to civil liability based solely upon the failure to obtain consent in rendering emergency medical, surgical, hospital, or other health services to any individual regardless of age, or that individual is unable to give this consent for any reason, and there is no other person reasonably available who is legally authorized to consent to providing such care. So it's a situation where the patient comes in, it's an emergency, the patient's incompetent, and there's no readily available surrogate. Then in that situation, the physician or hospital can act in good faith and provide care that's necessary so long as it's not inconsistent with the patient's prior expressed wishes. Okay, those are the general consent rules, and those consent rules, those general consent rules generally apply to any patient who comes in, whether they're a mental patient or not. The net result of that is, hey, you usually don't have to invoke those mental hold statutes, the special mental hold statutes, if you've got a competent patient who comes in and consents to their own health care. If they're consenting to their own health care, you can provide the care pursuant to the general consent statutes. You don't need to invoke the mental hold. Similarly, if the patient's incompetent, but you've got a surrogate who consents to their care, you just generally don't need to invoke the mental hold. Or if it's an emergency patient and the patient is incompetent and there's no surrogate available and you need to provide that care to mitigate that, you can go ahead and do that. You don't have to necessarily invoke the mental hold statute under those circumstances. You can go ahead and provide care under the general consent statutes. Now, it may be that you're concerned because you take care of this immediate problem, but down the road you think that there may be a situation where this patient is they're mentally unstable or incompetent or otherwise satisfy the criteria, so maybe you want to initiate the mental hold process, but initially, however, you can go ahead and provide the care without having to go through that process. Now, it's possible that you may need to initiate that mental hold, on the other hand, if it's a situation where the patient refuses care, or maybe the surrogate refuses care, or maybe you cannot locate the surrogate and the patient's refusing care. In those situations, you're afraid the patient's going to get up and walk out, or in those situations, you may need to initiate that mental hold. But again, remember that the mental hold is not necessarily to go ahead and provide ongoing treatment for that patient. It's to hold that patient so that you can get an order from the court authorizing the ongoing treatment. So let's talk about those different mental hold statutes, particularly the 72-hour administrative hold, the 24-hour protective hold, and the shelter care statute for minors. The first is the 72-hour administrative hold. Now, this applies if the patient is a voluntary patient in a facility. The statute defines a facility as any hospital, institution, mental health center, or other organization designated in accordance with rules adopted by Health and Welfare is equipped to initially hold, evaluate, rehabilitate, or provide care or treatment for the mentally ill. It's not necessarily just any hospital. It's probably in the hospital context, you're probably looking at a psych hospital or a hospital with a psych unit that has otherwise satisfied the requirements in the Idaho licensing regulations to provide psych services at the facility. I presume that that's what it applies to, although we don't have any cases. So if you're talking about a 72-hour administrative hold, you're really talking about a hold that can be initiated in the psych unit or a psych hospital. That's probably what that pertains to. Also, it only applies to voluntary patients, meaning those patients that have been admitted to the facility for observation, diagnosis, evaluation, care, or treatment pursuant to a specific statute, Idaho Code 66-318. Who are those voluntary patients? Those are the patients, they've been admitted voluntarily. Who can admit the patient as the voluntary patient? Well, if the patient's over 18, they can request their own care. If they're an emancipated minor, the patient may request their own care. If the patient's over 14, the patient can request their care, but you generally have to notify the parent or the guardian so that they understand what's going on, and presumably they can come in there and petition to have the patient released. If the patient's under 14, you've got to have the parent or guardian requesting the care, and if they are going to receive care in an inpatient treatment facility, you've got to have a designated examiner who recommends the care. If the patient lacks capacity to make informed treatment decisions, then you've got to have the guardian requesting the care, and if it's going to be care provided in an inpatient treatment facility, you've got to have the designated examiner recommend the care. Now, that's what you need in order to have a voluntarily admitted patient. Now, it used to be under the existing statute prior to July 1st, 2017, that only the director of the facility can admit a patient as a voluntary patient. But that raised concerns for some psych units who may not always have, who wanted to use, for example, mid-levels to admit patients for psychiatric care at a psych unit. So this past legislative session, the statute was amended so that effective July 1st, 2017, the patient may be admitted as a voluntary patient to a psych facility by the facility director or practitioner granted admitted privileges at that facility. That's generally a physician or a PA or an advanced practice registered nurse. So effective July 1st, your physicians and mid-levels can admit patients to the psych units. Now, the facility director or practitioner must refuse admission if the patient lacks capacity unless the guardian requests care. All right, so that's all situations where you've got a voluntary patient, you've got them in there. What happens if the voluntary patient decides they want to get up and walk out? Well, that's where the 72-hour administrative hold comes into play. In that situation, the facility director may hold a patient who has requested a release or whose release has been requested by the parent or the legal guardian if you satisfy the following criteria. These are the criteria for initiating that 72-hour administrative hold. The patient has to be voluntarily admitted to the facility. Of course, if they weren't voluntarily admitted, then there's some order out there that requires them to receive the care, and so this really doesn't apply. But if it's a patient who's voluntarily admitted to the facility, the patient or the authorized surrogate requests their release in writing, and in that situation, the facility director can initiate this 72-hour administrative hold if they think that the patient needs to be hospitalized because of ongoing problems. That facility director can initiate that hold for up to 72 hours, excluding Saturdays, Sundays, and holidays. The purpose of that is to obtain a designated exam, and so that the facility can initiate commitment proceedings to get an order so that they can go ahead and provide ongoing care for that particular patient. All right, that is the situation for, a couple of other things. So if you've got a 72-hour administrative hold, you want to initiate that. If you're at that facility, make sure that you document that those criteria were satisfied, that the patient was voluntarily admitted, that the patient now seeks to leave. Obviously, you don't need to initiate the hold if the patient's happy staying there. Or facts that show that the patient should be hospitalized against their will. You need to show why that patient needs ongoing care. That director of the facility is the one who initiates the hold. Although a physician or a practitioner can admit the patient, the statute allowing for the 72-hour administrative hold specifically, that was not amended. So it has to be the director of the facility that initiates that hold. Within the 3 days of initiating that hold, then that facility is going to have to take steps to obtain the designated exam and initiate the application to provide continuing care. If they don't, then presumably that administrative hold will expire, and that facility needs to make the decision about whether or not they're going to try to continue to hold that person without appropriate authority. All right. That is the 72-hour hold. Again, that applies if you are a psych facility. If you're not a psych facility, you're just a critical access hospital or other general acute care hospital without psych services, we're really talking about the 24-hour protective hold. That's the main topic for today. Under the Idaho statute, a 24-hour mental hold or protective hold may be initiated at a hospital by either a peace officer or a medical staff member, physician's assistant, or advanced practice registered nurse at a hospital to which the person is brought for care. Up until a few years ago, it used to be that the mental hold had to be initiated by a physician. Well, the problem is in a lot of rural facilities, they're staffed by PAs, NPs, other mid-levels. And so the statute was amended back in 2013 to expand that so that that 24-hour mental hold may be initiated by a physician or also a mid-level. They can initiate that mental hold if the officer or practitioner has reason to believe that the person is gravely disabled due to mental illness, or the person's continued liberty poses an imminent danger to that person or others as evidenced by a threat of substantial physical harm. So you've got to have one of those two. Those are very precise definitions. Let's talk about the definition of each. So the first is the person has to be gravely disabled due to mental illness. What does mental illness mean? Well, mentally ill means that a person who, as a result of a substantial disorder of thought, mood, perception, orientation, or memory, which grossly impairs judgment, behavior, capacity to recognize and adapt to reality, requires care and treatment at a facility or through outpatient treatment. So the person would have to be mentally ill, but also they would have to be gravely disabled as a result of their mental illness to satisfy the first test. What does gravely disabled mean? That means a person who, as a result of mental illness, is in danger of serious physical harm due to the person's inability to provide for any of his own basic personal needs, such as nourishment or essential clothing, medical care, shelter, or safety, or the person lacks insight into his need for treatment and is unable or unwilling to comply with treatment, and based on his psychiatric history, clinical observation, or other clinical evidence, he does not receive and comply, or if he does not receive and comply with treatment, there is substantial risk he will continue to physically, emotionally, or mentally deteriorate to the point that the person will, in the reasonably near future, be in danger of serious physical harm due to the person's inability to provide for any of his own basic personal needs, such as nourishment, essential clothing, medical care, shelter, or safety. So that is the first test. The first test, are they gravely disabled due to mental illness? Alternatively, you can initiate the mental hold if the patient is likely to injure himself or others. It's either or. You got to have either gravely disabled due to mental illness or the patient is likely to injure himself or others. What does that mean? Well, that means that there's a substantial risk that physical harm will be inflicted by the proposed patient upon his own person, as evidenced by threats or attempts to commit suicide, or inflict physical harm on himself, or a substantial risk that the physical harm will be inflicted by the proposed patient upon another, as evidenced by behavior which has caused such harm or which places another person or persons in reasonable fear of sustaining such harm, or the proposed patient lacks insight into his need for treatment and is unwilling or unable to comply with treatment, and based on his psychiatric history, clinical observation, or other clinical evidence, if he does not receive and comply with treatment, there's a substantial risk he will continue to physically, emotionally, or mentally deteriorate to the point that the person will, in the reasonable near future, inflict physical harm on himself or another person. Quite a mouthful, but that's the second standard. Now, note that that first standard, gravely disabled due to mental illness, that's linked to mental illness. The second standard, at least in the section dealing with initiating the mental hold, has a separate standard for likely to injure himself or others that isn't necessarily linked to mental illness. So you may have a situation where a person comes in who is suicidal. They may not have a mental illness. They may be suicidal, but maybe they're completely competent and they know full well what they're doing. They may not be mentally ill, I suppose, but they still may satisfy this test for likely to injure himself or others because that could be evidenced by threats or attempts to commit suicide or inflict physical harm on himself. Okay, those are the standards. If those standards are satisfied, then you as a healthcare professional, either a physician or a mid-level, you can go ahead and initiate that mental hold. We'll talk about that in just a minute. Now, that 24-hour protective hold is designed to apply to those two situations we just talked about, gravely disabled due to mental illness or likely to pose a substantial threat because of those particular circumstances. That mental hold is not appropriate, and it specifically does not apply just because a person has epilepsy or has a developmental disability or has a physical disability, has an intellectual disability, is impaired by chronic alcoholism or drug abuse, or is simply aged, unless in addition to such conditions, such person is mentally ill. Remember when this statute first came out, there was maybe the definition of mental illness perhaps was not as well defined or as well known as it is today, and so a lot of people assume that if you had epilepsy or had an intellectual disability that you were deemed to be mentally ill. This statute just confirms no, that's not necessarily the case. Note that that one concerning impaired by chronic alcoholism or drug abuse. That is kind of an interesting one because a lot of times a patient shows up at a particular facility, they are intoxicated, you wonder if you should go ahead and initiate a mental hold just to hold the person for 24 hours while they detox. Well, that may not really be appropriate in those particular situations. You probably don't need a mental hold because they've got a medical condition that you could probably go ahead and hold them, although I suppose it's possible that you could satisfy the mental hold situation if you need to because that person may be likely to harm themselves. The problem with doing that, though, remember that the purpose of the mental hold is so that you can get a designated exam in there. It's not necessarily to treat somebody when you don't otherwise have consent. It's not to provide whatever medical care you may think that that person needs at that particular point in time. It's to hold the person so that you can get the DE. And if that person's in there and they're impaired by drug or alcohol, then you may not be able, it may take a longer time for that person to sober up so that you can actually get the DE and make that DE effective. So be careful about simply initiating a mental hold just because a person needs to detox. If you do initiate that 24-hour protective hold, notice must be given to the patient's immediate relatives of the patient's whereabouts, let them know where the patient is, and the reasons for detaining the persons. Now, the statute does not specify who gives that notice, whether it's supposed to be given by the police or whether it's supposed to be given by the hospital. As a practical matter, the hospital should make sure that that notice is given in order to ensure that the statute is satisfied. Again, the purpose of that mental hold is to initiate proceedings to determine whether or not that patient should be committed for further ongoing treatment. So there's a timeline. You initiate that mental hold for a 24-hour period. What's supposed to happen during that 24-hour period? Well, during that initial 24-hour hold, you petition the court, or you go to the, more appropriately, you go to the county prosecutor so that they can petition the court for a temporary hold. If the court orders that exam, then they will send you an order to continue to hold the patient. If the court denies the exam, then you're going to have to release the patient because you have no authority to hold that patient beyond that 24-hour period without, unless you have some other basis, some other authority to do it. For example, consent from the patient or consent from the surrogate. Now, if you are going to go to the court and you're going to get that petition the court for treatment, if that patient needs ongoing medical care in addition to and ongoing non-emergent medical care in addition to just simply detaining them while they get the designated exam. You want to make sure that that order that you get back from the court authorizes any necessary treatment that you may need to provide in the meantime. That's the safest thing to do. Otherwise, you still may be in a situation where you need consent from the surrogate or from the patient if they're competent in order to provide ongoing care. So you may want to work with your county prosecutors when you come up with those forms for filing that you get authority from the court to provide necessary care in the meantime while you're holding them. So you've held the patient, you've got 24 hours to petition the court for the temporary hold. If the court decides that they're going to go ahead and order the continuation of that hold for the designated exam, then that designated exam has to occur within 24 hours of that court order. That the purpose of that designated exam is to determine whether the patient is mentally ill and either gravely disabled or likely to injure themselves or others. If that exam comes back and when the exam comes back, they've got to submit a report to the court. That report has to be submitted within 24 hours. If that report indicates that the person should be held, that hold should be continued, then that prosecutor has 24 hours to initiate the commitment proceedings. Within that 24 hours, then that court has to go ahead and consider that, and they have to, if they grant it, they will have to order detention for up to 5 days while the court conducts a hearing to determine whether or not that person is going to be committed for ongoing care. If the court declines to extend that, then you don't have authority to hold that patient. You would have to look for some other authority to hold that patient. The statute specifically said if there is no petition filed within 24 hours of the designated exam, then you must release the patient, unless, again, you've got some other basis, including consent from the surrogate or something else, that would allow you to hold that patient. The statute says that you can't hold that patient in a non-medical unit used for detention of individuals charged with or convicted of a crime. You can't simply send that patient off to jail. Now, the situation arises quite often where that patient comes into a critical access hospital. That critical access hospital is not a psych unit, so they really don't have facilities to hold this patient, or they're not trained to hold this patient. This patient starts committing assault on the hospital employees or other patients. In that situation, what do? Well, you do what's necessary in order to protect your other patients as well as your staff. And if that patient's engaging in criminal behavior, then I think you call the police and tell them that, hey, we've got a criminal down here who's engaging in that conduct. In that situation, I think that the police are justified in taking that patient off to jail, not necessarily to detain him for a DE, but because that person is engaged in criminal conduct. Now, those can become somewhat sensitive, touchy-feely issues, and so usually it's best to work with your police department in advance to resolve those issues so everybody understands what the protocol is for handling those types of situations where you have the combative patient who's in there and you may not have the restraints or other means necessary to hold them. Speaking of restraints, when we amended the statute a couple of years ago, we made sure that the statute confirms that if you do have a mental hold situation, the hospital may use restraints or seclusion if it's necessary for this patient's safety or the safety of others. That includes chemical restraints or physical restraints, but of course you're still going to have to comply with the CMS conditions of participation dealing with restraints, so make sure that you're following your normal restraint policies. Well, what about if you are a critical access hospital, you're not a psych unit, what do? You're not authorized, you're not even licensed to hold these psych patients or render psych care. What do you do about that? Are you stuck with this person? No, when we amended the statute a couple of years ago, or a few years ago, we specifically confirmed that the hospital may transfer a mental hold patient to another facility. Of course, you're going to have to comply with the EMTALA requirements. That means that you're going to have to use appropriate means and personnel to provide stabilizing treatment to the extent you're able while that patient's at your facility. You're going to have to contact the receiving facility to make sure that they agree to receive the patient, and you're going to have to use appropriate means to transport the individual over to that other facility. Under EMTALA, if you've got another hospital with specialized capabilities, you're not a psych unit, but you want to transfer that patient to another psych unit, then that other hospital with psych capabilities has an obligation to receive that patient as long as that other facility really does have the specialized capabilities, unless that other facility is on diversion. In Idaho, unfortunately, we simply don't have enough psych beds, and so you have situations quite relatively frequently where other psych units don't have enough beds. If they don't have enough beds, then they don't have specialized capabilities, and they're not necessarily obligated to accept the transfer of that particular patient, and you may have to continue to hold the patient while you look for another place to transfer that patient. Also, beware that EMTALA ends once you admit the patient as an inpatient. So if you've got a psych patient or somebody under mental hold and you admit them to your facility as a regular inpatient, at that situation, that can cause you a couple of problems. The first is it could create some problems with licensure and survey if they come in there and it looks like you're now providing psych services in your unit. But more practically, once you admit that patient as an inpatient, then EMTALA ends. That means that that other psych unit, that other facility, no longer has to accept that patient. They're not obligated to accept the patient. Now, in Idaho, most of the facilities out there are pretty collegial and they're very professional, and they try to accommodate those transfers when appropriate. But just remember this, that if you admit that patient in your facility, that cuts off EMTALA, not only for you, but also for that facility that wants to receive the transfer or may otherwise or would be a candidate to receive that transfer. And if EMTALA ends, they would not necessarily be obligated to accept that transfer. So if you know that you want to send this patient out, be careful about admitting them, because that may limit your ability to transfer that patient elsewhere and may expose you to some licensure or survey problems. The statute specifically states that, hey, if you undertake to initiate these mental holds, we're going to provide you with immunity. It applies to not only detaining, failing to detain, we added that, so if you make the determination that you're not going to detain a particular patient, the diagnosing, transporting, treating, or releasing a patient per the mental hold law, if you are engaged in any of the activity, you get limited immunity if you comply with the procedure in the chapter, meaning that you've contacted the appropriate people, you've initiated that proceeding or gone through those hoops, and you otherwise act in good faith and without gross negligence. If you do that, then you have immunity for detaining, failing to detain, diagnosing, transporting, or treating or releasing the patient per the mental hold law. All right, let's talk about the shelter care situation. There are some prosecutors around the state that have taken the position that if you're dealing with minors, you shouldn't be relying on that 24-hour mental hold under 66-326. Instead, they state that you should be relying on the shelter care statute in Idaho Code 16-2411. They take the position that that statute in 16-2411 is more specific because it specifically deals with minors, that you ought to go for that one instead of the general statute in 66-326. Now, I'll tell you, when we revised 66-326 a few years ago, we contemplated that it would apply to adults and minors. Nevertheless, if you're dealing with one of those prosecutors who thinks that that's not the right statute, then you may want to address those situations with them in advance. Make sure that you are on board with the county prosecutor. So if you've got a mental hold situation involving a minor, that you know what the rules are going to be, whether that county prosecutor will be willing to go ahead and initiate a mental hold under 66-326 and get a designated exam, or whether they're going to say, no, you got to follow the procedures in 16-2411. Under 66-326 for adults, you apply that, remember, you apply that that 24-hour mental hold in order to get the exam to determine whether or not the patient should be committed for further treatment. In the case of minors, 16-2411 doesn't necessarily serve the same purpose. The shelter care statute in 16-2411 just simply says that you can detain the minor long enough to notify the parent or guardian and presumably remand the minor into their care, or if the parent or guardian refuses care, that you notify the police so the police can then initiate a shelter care hearing. The two standards may be somewhat different between 66-326 and 16-2411. As a practical matter, though, I think you're probably dealing with essentially the same elements. So let's talk about the requirements under 16-2411. That statute says that an unemancipated minor may be detained by a physician, physician's assistant, or advanced practice nurse at a hospital if they determine three things. The first is that an emergency condition exists. We'll talk about what that is. Second, that the person has probable cause to believe that the minor is suffering from a serious emotional disturbance as a result of which he is likely to cause harm to himself or others, or is manifestly unable to preserve his health or safety with the supports and assistance available to him. And third, that immediate detention and treatment is necessary to prevent harm to the minor or others. So you got to satisfy all three. Let's talk about each one of those tests. First, it has to be an emergency situation, emergency condition. What is an emergency? An emergency is a situation in which the minor's condition, as evidenced by recent behavior, poses a significant threat to the health or safety of the minor, his family, or others, or poses a serious risk of substantial deterioration in the minor's condition which cannot be eliminated by the use of supportive services or intervention by the minor's parents or mental health professionals and treatment in the community while the minor remains in his family home. So essentially that this is an emergency situation. Simply sending the patient back home probably isn't going to resolve it, that they need more help than is otherwise available. That's the first standard that has to be satisfied. In addition to that, it has to be related to a serious emotional disturbance. That's not necessarily a mental illness as in 66-326. The standard for serious emotional disturbance means an emotional or behavioral disorder or a neuropsychiatric condition which results in a serious disability and which requires sustained treatment or interventions and causes the minor's functioning to be impaired in thought, perception, affect, or behavior. The definition states that a disorder shall be considered to result in serious disability if it causes substantial impairment of functioning in the family, school, or community. A substance abuse disorder does not by itself constitute a serious emotional disturbance, although it may coexist with a serious emotional disturbance. So you get the minor who comes in, you're going to ask, okay, the test is, does this minor, is it an emergency situation, and do they suffer from a serious emotional disturbance that's likely to cause harm to himself or others? The definition for likely to cause harm to himself is, or to suffer substantial mental or physical deterioration. It's defined there in the statute. Similarly, likely to cause harm to others. It's pretty self-explanatory. It's evidenced by recent behavior attempting to cause harm to others. Okay? So if you've got that standard, if you satisfy that standard, then you can go ahead and detain the minor for a limited period of time. We'll talk about that in just a second. Now, what happens if that patient comes in there, that minor comes in, but they require facilities that you don't have? The statute specifically says that if the hospital does not have an appropriate facility to provide emergency mental health care, it may cause the minor to be transported to an appropriate treatment facility. An appropriate treatment facility is one that's been approved by Health and Welfare to provide those types of services. If they come in and you do have those facilities, that the health care professional shall notify the parent or the legal guardian, if known, as soon as possible, and shall document in the patient's chart the efforts to contact the patient or legal guardian. So, again, the purpose here is to notify the parent or the legal guardian so that you can get consent or you can send the patient home with the parent or guardian if that's appropriate under the circumstances. If you can't contact the parent or legal guardian, then the statute says, if you can't locate them or contact them, the healthcare professional shall cause a report to be filed as soon as possible and in no case later than 24 hours with the Idaho Department of Health and Welfare or an appropriate law enforcement agency. So you get the state involved. So the state can then step in and assume responsibility, presumably, and authorize any necessary care or treatment. Now, the purpose of this shelter care, again, is to hold the patient long enough to contact the parent or the guardian. The statute specifically says that a minor may not be detained against the parent or guardian's explicit direction unless the minor is taken into protective custody by a peace officer. So you, as healthcare professionals, don't have the authority under this shelter care statute to detain that patient against the parents' or guardian's wishes. The most that you can do is detain them long enough to contact the police so that the police can then show up and initiate a protective hold. And that's when they can, the police can show up and have the patient transferred to another facility. The statute says a minor may be detained for a reasonable period of time necessary for a peace officer to be summoned to the hospital and make a determination whether he or she should initiate protective custody. But you can't do that on your own. At most, you at the hospital, you can detain the patient long enough to contact the police, and then the police, if they want to, they're the ones who can initiate a shelter care proceeding. You can't do that on your own, unlike Title 66-326 if you're doing that 24-hour protective hold. This is a different statute. Now, if the police officer shows up and they decide that, yeah, a protective custody is appropriate, then that if the police officer takes the minor into protective custody, the police officer shall immediately transport the minor to a treatment facility or mental health program approved by DHW for that particular purpose. So comparing the 24-hour mental hold versus the shelter care, the 24-hour mental hold per 66-326, it certainly applies to adults. I think it probably it doesn't exclude minors, but you've got prosecutors out there who may disagree and won't go to the court for a to initiate mental hold proceedings under 66-326 if you're a minor. Again, that's something you may want to work out with your county prosecutor. The purpose of that is to hold long enough to obtain that designated exam. You have the 24-hour period so that you can file the petition. The court will rule on that within the 24-hour period, and if the court wants to, they'll order longer detention. But the key there is you hold that person not necessarily to provide ongoing care or to just detox the person. You're holding them so that you can get the designated exam. In contrast, that shelter care, that applies to unemancipated minors. Those are minors who have not been emancipated either by the court or by marriage or having been married. The purpose of that is to hold long enough to notify the parent or guardian. And then the parent and guardian can show up and either consent to ongoing care, or if they refuse consent but you think that the child needs additional care that that family can't consent, then you've got a couple of options. You could you can contact the police and have the police show up to initiate the shelter care, or I guess you could turn the patient back over to the family members and document that they were leaving against advice, or you could perhaps report the parents to if it's a situation involving child neglect. If you do take that minor into shelter care, you're detaining them long enough to contact the parents and or the police, then you've got to take reasonable precautions to safeguard and preserve the personal property of the minor unless a parent, guardian, or responsible relative is available to do so. All right, that is a brief overview of the relevant mental hold or shelter care statutes. Just a quick word about hospitals offering psych services. The Idaho licensing statute for hospitals, or the licensing regulation, states that if the hospital offers psychiatric services, it shall be organized, staffed, and equipped to provide inpatient and outpatient treatment to the mentally ill, and they have to satisfy the requirements that are set out in IDAPA 16.03.14.470, and there's a bunch of requirements that have to be satisfied. If you're going to provide psych services at your facility, at your hospital, then you're supposed to satisfy these particular requirements. Well, that creates somewhat of a problem for those patients who show up at your facility with a psych problem. You're not licensed to provide ongoing psych care, but yet you've got this patient there, and under EMTALA, you can't just turn them away. You've got to provide stabilizing treatment and or an appropriate transfer to another facility. So what do? Well, fortunately, Health and Welfare has confirmed that they're not going to cite you for providing psych services in your facility as long as you're doing it just to stabilize the patients while you're trying to transfer the patient someplace else. A few years ago, quite a few years ago now, I heard of a situation where it was one of those unfortunate situations where a critical access hospital was allegedly, they got in a psych patient, they couldn't find any place to transfer the patient, they allegedly admitted the patient as an inpatient because they were just trying to find some place to transfer him, and they subsequently allegedly got cited for continuing to hold that patient or providing psych services. I think in more recent conversations that we've had with Health and Welfare, they've said, look, that's not the intent. As long as you're not undertaking to provide ongoing psych services in your unit, you're just stabilizing the patient long enough to transfer them out, then you shouldn't have a problem with Health and Welfare. But you're going to want to make sure that you're documenting those efforts, that you're not really undertaking to provide ongoing psych services in your particular unit. A more recent issue has come up, particularly with the Idaho Hospital Association. They've been pursuing the issue with health and welfare about to what extent could rural hospitals provide some level of psych services just to help stabilize patients who are dropped off at their facility. Could they, for example, enter into telemedicine agreements with psych service providers, not to provide ongoing treatment or ongoing inpatient or outpatient services, but merely to stabilize the patient long enough to satisfy their EMTALA obligations while they're trying to transfer the patient elsewhere. In my conversations with health and welfare, they've indicated, yeah, that should be fine. They are willing to work with the hospitals on coming up with appropriate parameters for those types of situations. And we will continue to seek additional guidance from health and welfare. I understand that health and welfare is actually working on a guidance document that they can send out to the hospitals, providing some direction on those issues. All right. In summary, if you've got a patient who shows up at your particular facility, you got to have consent to provide care. If it's a medical issue, you're generally going to follow the general consent principles, meaning you've either got to have consent from an authorized patient, either the patient who's competent themselves or in prior advance directive, or you need to get consent from an authorized surrogate. If there's no time, the patient's incompetent, can't find a surrogate to give you consent, you can go ahead and provide emergency care necessary to provide that care in the meantime. If it's a mental health issue, patient shows up with a mental health problem, well, if you've got consent from the patient or the patient's authorized surrogate, you can always rely on the general consent statute. You don't necessarily need to initiate the mental hold. On the other hand, if it is a situation where the patient's refusing care or you can't find a surrogate or the surrogate's refusing care, in those situations you may need to initiate a mental hold. If you are a psych facility, you could initiate that 72-hour mental hold if you satisfy the requirements, meaning that the patient was a voluntary patient but now wants to leave. If, in most cases, you're really dealing with a 24-hour situation, 24-hour protective hold, you just need to make sure that you satisfy the requirements for that. Patient has to be gravely disabled due to mental illness or otherwise likely to injure themselves, and you've got to initiate that mental hold process, initiate the petition for the court to get the order to provide a designated exam. You've got to do that within the 24-hour period. That's the purpose for the mental hold. If it's a minor, then you may want to consider initiating the shelter care proceeding. But again, the purpose there isn't necessarily to hold them for 24 hours to get a DE. You can't do that on your own. The only thing you can do is detain them long enough to contact the parents. If the parents refuse care and you think the kid needs care, then you can detain them long enough to contact the police, so the police, if they choose to, can initiate protective hold, but you can't do that on your own. That is a quick summary. If you have questions on any of those things or the application for either me or for health and welfare, by all means, shoot me a question using the chat feature or just send me an email offline. If you would, just refer to this program to make sure that I'm responding to a question that was raised at the program, and we'll make sure that we get that resolved. Other than that, thank you very much for your participation. I hope this has been helpful. We certainly appreciate the Idaho Hospital Association in making such programs available for its members and being responsive to the questions that its members have. Thank you.